Ladies and gentlemen, the Supreme Court of India today has delivered a historic verdict that will shape the way the world's biggest election will be fought. 2 months ahead of the elections, the Supreme Court has launched a surgical strike on electoral bonds. Electoral bonds, as you know, have been the primary source of funding for political parties, especially the BJP, for the last 6 years. Now, the court has not just buried the scheme, it has also told the State Bank of India to give unencashed money back to the donors. Not just that, the court has also asked the SBI, in fact, ordered them to reveal the name of secret donors. They are saying make those notes public, make those notes public. So there are interesting times that lie ahead once those names of secret donors are actually made public. Why did the Supreme Court do what it did? You will hear from the Chief Justice of India in just a bit, but essentially the Supreme Court is acknowledging that there are no free lunches in this world. So if a corporate donor is giving you crores of rupees, gets a tax exemption on it, and has a law that lets his donation be secret, then it's pretty clear why the guy is donating to you in the first place. It's called quid pro quo. That is a word the Supreme Court has used. So essentially, the court is calling the scheme unconstitutional and saying that it violates a citizen's right to know. The government's argument about electoral bonds wiping out black money from elections was also called out by the Supreme Court. Listen in.
The anonymity of the contributor is intrinsic to the electoral bond scheme. The electoral bond scheme is not distinguishable from other modes of contributions through banking channels such as checks, transfer through the electronic clearing system, or direct debit if the anonymity component of the stream is struck down. Thus, the electoral bond scheme 2018 will have to be struck down as unconstitutional. At a primary level, political contributions give a seat at the table to the contributor. That is, it enhances access to legislators. This access also translates into influence over policy making. There is also a legitimate possibility that financial contribution to a political party would lead to quid pro quo arrangements because of the close nexus between money and politics. Quid pro quo arrangements could be in the form of introducing a policy change or granting a license to the person making financial contribution to the political party in power. The electoral bond scheme and the impugned provisions, to the extent that they infringe upon the right to information of the voter by anonymizing contributions through electoral bonds, are violative of Article 19(1)(a). That Clause 7(4) of the electoral bond scheme balances the right to information of the voter and the right to information privacy. We are of the opinion that Clause 7(4) of the electoral bond scheme is not the only means for curbing black money in electoral financing. There are other alternatives which substantially fulfill the purpose and impact the right to information minimally when compared to the impact of electoral bonds on the right to information. On an overall balance of the impact of the alternative means on the right to information and its ability to fulfill the purpose, for contributions below 20,000 rupees, contributions through other means of electronic transfer is the least restrictive means. For contributions above 20,000 rupees, contributions through electoral trust is the least restrictive means. Thus, the infringement of the right to information is not proportionately justified for the purpose of curbing black money and electoral financing.
Joining me now is Dr. Abhishek Singhvi, who's a 3-time sitting MP from the Congress Party, an eminent jurist as well. Dr. Singhvi, good evening and thank you very much. Many people are saying this is a triumph of transparency. Others are calling this a historic verdict. Is that your view and opinion as well?
Well, it could certainly qualify in the category of historic judgments, not only because it's an important, detailed judgment, but because it's a unique issue. The issue never arose in the entire 75-year history of India. So any judgment or issue which has never been really addressed, it's the intersection of corporate law, of power of review, limits of transparency, level playing field, elections, democracy, these are a cocktail of issues which have never arisen in any case, even, and therefore it is unique, it is historic. Number one. Number two, uh, I welcome it, I applaud it. It's a much needed judgment, very comprehensive. It deals frontally with the issue, doesn't avoid issues. I only fault it in one sense, not fault this bench, which has done this job very well and comprehensively and took time out to do it. But the bench which passed an interim order in 2019, Shreya, there is some introspection required there. You allowed
Yeah.
something conceived with ulterior motives, born in deceit, bred and reared with clear duplicity, known even by its creators to be opacity personified. You allowed it a free run for almost 2 election cycles, so 4.5 years. It served the purpose for the masters who created this clear scheme designed to get money, A, B, get money in proportion of 100 to Shreya, 1 to Singhvi. C, keep the identity of donor amount actually opaque and hidden. D, justify it on a ridiculous argument that, of course, it can be known by a bank. It is known to the government. What if it is not known to you? You have no right to know it, which is the argument, by the way, which they have debunked and lampooned in the judgment. And therefore, E, something which makes a slanted, non-level playing field of elections, where money matters a lot, and therefore impinges on basic structure by making democracy itself being affected. So it's very important.
Mr. Singhvi, you speak of level playing field and how electoral bonds actually skewed it. Now, fact is that more people vote for the BJP than they vote for the Congress party. Fact is, if 9 people vote for Shreya and only 1 person votes for Mr. Singhvi, then it is highly possible that 9 out of 10 people will be willing to pay Shreya to fight an election and only 1% of the people will be willing to pay Mr. Singhvi. How can that be an argument against electoral bonds?
In fact, that is the precise point which works against the electoral bonds, not in favor as you're putting it. The issue is not, the court has not said that Shreya can't get 9 and Singhvi cannot get 1. The court has not compelled you to donate equally. It can't, it has not. That's not the issue at all. The court has said that what is the reason to shroud in secrecy the fact that Shreya gets money from whom and how much from whom. That is different from saying the totality aggregate of what Shreya gets is 9. That is known. But that 9 is composed of Mr. A, B, C, D, E, and each has given 1 rupee, 2 rupees, 4 rupees. Now, that second point, why that is vital is because the transparency is not an end in itself. It's a means to an end. But the end is equally important as the means, and that is accountability. If you know that Mr. A and B and C are repeatedly donating in large sums, 9 out of 10 rupees to Shreya, then you are able to check what power Shreya wields, where she wields it, how she wields it. Does she wield it more in Chhattisgarh or less in Haryana? What is the nexus of the project which one of these donors gets in those states? So that is what else is democracy? It cannot ever say, so therefore you framed the question in the wrong way. That's not what the court is saying. That's not what the issue is raised. The issue is, please give, I am saying why 9? Give all 10 to Shreya. Let the world know. Why are you scared? Let the world know you give 10. Because the moment you give 10, the whole world will be monitoring you and finding out what favors have flown between you and Shreya or vice versa. And that's about all. So the heart of the matter is democracy. One more thing, Shreya, people have forgotten. The heart of the matter is transparency and, of course, accountability, which goes with transparency. But the second thing they've forgotten, there is a very important equal issue raised by the court. The court raised 2 issues, not 1. The framers, when they conceived this scheme of opacity, conceived in deceit, knew that they had to remove the limit on donations.
Correct.
Decades, there was a limit. So the court has also held that removal of the limit to donate is itself arbitrary. And the two go together. Had they kept the limit as it is, then the opacity would have mattered less. So the clever people they removed the limit altogether and then said, come one, come all, give everything in an electoral bond. Nobody knows who's given what for what.
No, we don't know who's giving, but we do know that who is who's receiving it. There is enough and more data that tells us that more than 50% of the electoral bonds have gone to the BJP, but that could also primarily be because they are the party in power, right? Now, the BJP keeps saying that the India Alliance, and especially the Congress, keeps saying quid pro quo, quid pro quo. Where is the quid pro quo? Where is the scam that you seem to be implying there is?
We will now start telling you when the data comes out. Firstly, the point is that's again the self-defeating point they are making. The whole point is that where is the scam, where is the quid pro quo, could not have been said as long as the electoral bond scheme was on. That's the first part. That's the meaning of opacity. I told you, it doesn't tell you who are the people who gave to Shreya and how much they gave, and then correlate it subsequently to Shreya's actions and those people's actions. That happens subsequently. That's a matter of my investigation. Both cannot be done with the opaque shroud. In fact, today the shroud remains. The last para of the judgment says that shroud will be uncovered by the SBI revealing to EC. And then it says further that within 3 weeks of the SBI revealing all this to EC, the EC shall put it up on its website. So that's where this whole accountability process will start. Takes time. But the point of the matter is that there could be none of that without the data being available first from the SBI to the EC and then on the EC to the website. That's the heart of this judgment.
Okay. Okay, so we'll see if this SBI actually delays that data, saying we don't have it. I mean, if it does, we know why they are doing it. But Mr. Singhvi, corporates in India can very well come together and say that when we contributed, when we bought these electoral bonds, we were given an assurance, a guarantee under law that our names will be hidden from the public, that these are anonymous donations. And what the Supreme Court here, therefore, is trying to do is unlawful. How can they, 6 years down the line, wake up and say no, names of all corporates who donated via electoral bonds will now be made public? How's that fair?
I am sure, Shreya, that your clever legal brain is being used by those who created this bond scheme, and there's going to be making a proxy application from such donors soon to try and avoid doomsday. As a lawyer, I have no doubt that application is waiting to be born to try and delay the inevitable. Number one. Number two, it's not going to meet with any success. Why? If you make an unconstitutional violative of Article 19(1)(a), violative of Article 14, there is no defense to say that I participated in an illegal scheme. Now that the court has held it to be unconstitutional, you revalidate it because I expected it to be anonymous. It's like saying that you create an illegal amnesty scheme. The court strikes it down. Everybody says, no, please keep my name secret. Why? You know, it's tough luck. You may be a collateral damage, but the people who created it created an unconstitutional scheme. The fruits of a poison tree mean that all people who eat it will also die.
Okay. Mr. Singhvi, then here's a logical question. Pre-2017 election funding in this country was rotten, which is why the BJP says we had to look at electoral reforms. Electoral bonds were one of the way. Now the Supreme Court is telling us that even the electoral bonds are rotten. So pre-2017 is rotten, post-2023 is rotten as well. What do you do? My point is, would India have been served better and its elections served better if the Supreme Court had let the electoral bonds stay, but removed the clause of anonymous donations to say whoever wants to donate can come and donate, but it will not be anonymous?
Exactly similar argument was raised during the course of arguments, that if you do away with this, you'll get a worse situation. Don't do away with it because you get a worse situation. The answers are very interesting. One, if there is a pre-existing situation which is superseded by an unconstitutional scheme, no doubt a scheme is held unconstitutional only retrospectively, as it has now been done in 2023. But if a pre-existing state of affairs is revived by the setting aside of an unconstitutional scheme, that is no answer that scheme should not have been held unconstitutional. That scheme has to go. What was there before, we'll see. Number two, the court said we're not inhibiting you to create any other scheme.
No.
Create 20 other schemes. When they come before us, we'll again test them. But yours is not the last word, that whatever scheme I create must be kosher and held by your lordships to be kosher. Because if you remove it, there'll be, after me, the deluge, as the French nobility said. There is no such thing. Let the government come with a proper scheme. The scheme could be a scheme where everything is disclosed and people, donate. The scheme could be some other variant. We don't know. You can't start opining in anticipation on a non-existent scheme. But you cannot uphold this scheme on the ground that without this, there'll be chaos on the old scheme. That is completely wrong argument. It has been debunked by the court time and again.
Do you see, and I'm asking you this question because this is a question that is floating in the air, do you see the government going ahead and bringing in an ordinance to counter the Supreme Court's surgical strike? After all, these elections are barely 2 months away and everyone could do with some money.
I have no doubt that this government can try anything and they may try that. But they would be really foolhardy to do it. I think it will be ridiculous. They'll paint themselves with mud for the simple reason that the two principal grounds on which the scheme has been struck down in the last era is very clear, is on 19(1)(a) and on 14. Something unconstitutional under 19(1)(a) and 14 cannot be revalidated by a statute or an ordinance. A statute or an ordinance is well below 14 and 19. So you have to pass an ordinance or statute under your theory, which says whatever was there in the bond scheme, we are now reproducing it in an ordinance, which is a statute, right? But whatever is in the scheme has already been held to be violated of 19(a) and 14. Then how can the statute, which repeats the same thing, survive?
Mr. Singhvi, my last question to you. How do you, given the fact that this verdict has come...
Mr. Singhvi, my last question to you. The fact is that the verdict has come 2 months before the elections. Do you see it in any way shaping these upcoming elections? Because look, fact is the verdict was reserved by the Supreme Court on November 2nd. So I'm fairly certain that all political parties, especially the BJP, had seen this coming, and therefore the money required for the polls is already with political parties. So do you see this verdict shaping the upcoming election in any way?
I entirely agree with you, and I started my comment in many programs that I did say briefly in your show, that this judgment is very adequate. I welcome it. It's very comprehensive. It's very good. And it's something which had to happen, should have happened. But I fault the Supreme Court as an institution, not this bench, that in 2019, when you passed an interim order, it was incumbent and obligatory on that bench to take up the matter in the near future and decide it. Not doing so has meant that you have allowed the fruits of the poison tree to be enjoyed by its creators almost, I use the word almost, between two electoral cycles. The most important being 2019 itself, the national elections. Now, we can't rewind the clock. I think that it's an institutional failure on the Supreme Court's part not to take it up then and decide. This bench has done a wonderful job in fast-tracking it and hearing it, but that bench can be faulted. However, it will have some marginal impact because certainly what monies have come in will be known, can't be taken away, etc. But future things have stopped. There are still a few months left to elections, A. B, there is a far greater degree of care, transparency, and accountability now. So to that limited extent, I agree with you that 2 months is not much. So largely the fruits of the poison tree have been enjoyed.
Okay.
But then that's the way the law system functions. You can't do anything about retrospectivity or rewinding the events.
Okay, Mr. Singhvi, we'll leave it there for the moment. Thank you very much for your perspective on the big verdict that has come out from the Supreme Court. The Supreme Court hitting where it hurts, actually, saying that all the bonds that have not been encashed, the money has to go back to the donor. So that's a double whammy for political parties. Thank you very much, Mr. Singhvi, for joining us, and good night. And thank you to our viewers for watching, and good night to them as well.